The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, ladies and gentlemen, and welcome to this IT governance webinar on the first steps toward GDPR compliance. I'm Alan Calder, and I'm going to be your host this afternoon. I'm the founder and chief executive of IT Governance, which is a company I set up about 12 years ago in order to provide a single source for everything to do with IT governance, cyber risk management, and IT compliance. The book I wrote back around the turn of the century, IT Governance, an International Guide to Data Security, is now in its 6th edition, and in a weird kind of way was the start of a business which now provides products and services into almost every country on the world. We have offices obviously in the United Kingdom, but spread across Europe and in North America, as well as businesses in the Gulf, Asia Pacific, and Southern Africa. We are very much focused in and around cyber resilience, data protection. GDPR is a very major part of our business over the last couple of years, but cybersecurity and standards like ISO 27001, which are as tied up in GDPR as they are in general cybersecurity, are just as important. PCI, business continuity management, penetration testing, cyber essentials, all of them delivered through a range of activities such as books and toolkits, software. We have a very substantial classroom and in-house training business. We have e-learning software, technical security, consultancy, certification. In other words, one place you can go to access whatever package of products and services is appropriate to tackle your specific needs with your specific project at this time. I'm going to be talking today about the regulatory landscape, the territorial scope of the new General Data Protection Regulation, which comes into, which is enforced from the 25th of May this month, so around about 16 days away. The principles of the EU GDPR, we're going to look at breach notification rules and data subject rights. They kind of go hand in hand. We're going to look at changes to consent and other lawful basis for processing personal data. We'll look at the relationship between controllers and processors and the liabilities of processors, the role of the data protection officer. We'll touch briefly on international transfers, and of course the role of the European Data Protection Board, which will come into existence on the 25th of May. You'll probably find that you have questions you want to ask as I go through this. Please do. In your GoToWebinar dashboard in front of you, you'll see towards the bottom of the panel of options a line called questions. If you click on that, you'll find that you can type questions into it. Please do use it to ask the questions that occur to you as I'm going through the material. And then when we get to the end, there is a portion of the webinar which is reserved to be able to handle questions. I'll answer whatever questions you've got. I'll read out the questions that there are, and I'll share with you the answer that there is. So do use the question option, and usually the first question is, will copies of the slides be made available? And yes, they will. They'll go out later on this week, early next week. So starting point is the nature of European Union law, and there are really two types of law. There is a directive and there's a regulation, and they're very different in terms of their impact. A directive is something the European Commission uses to tell member state governments what they must do. The existing Data Protection Act in the United Kingdom is based on a directive, and a directive is therefore something which, because it tells member states what they have to create laws for, also gives member states the opportunity to do more in those laws than the bare minimum set out in the directive. A regulation, on the other hand, is a law. At the point when it passes through the complex European Commission structures, including the agreements by the deputies, it becomes law as written by the European Commission, as contributed to by all the member states. And it goes into law irrespective of whether or not member states pass enabling laws. Most tend to do so. The UK certainly is. And so the Data Protection Bill currently going through the UK House of Parliament is the enactment into British law of GDPR. And GDPR would apply in the UK in any case beyond May the 25th, up to the date of Brexit. That's the nature of EU law and the force of European Union treaties, but the effect of passing it into British law means that it will exist beyond Brexit as well. So GDPR, as the name indicates, is a regulation. So the law as written, as released just under 2 years ago, is effectively the law that's going to go into place with some derogations. Member states have some specific areas where they can make their own decisions about how they're going to deal with data protection. And I'll touch on one or two of those through the course of this webinar, which all in all is due to take around about an hour, and that's including the questions. So about 45 to 50 minutes of me talking and then 5 to 10 minutes worth of answering questions. The model of data protection under the GDPR looks a bit like this. So there's us, we're data subjects. We own our own data is the starting point for GDPR. It says all of the information that exists about you, you own. You're entitled to have it dealt with in a way that you're aware of, that you know about, and that is lawful. Organizations that collect your data are called data controllers, and they're a data controller because they determine the means and purposes of processing data. And a data controller can ship data out to a third country as long as it's got a lawful basis for doing that. We'll look at that later on. And it can share data with a third party. GDPR doesn't prohibit that. It just says that you have to do so legally. So GDPR recognizes that there are duties that the data controller, typically an organization, has in respect of data subjects, because data subjects have rights. And the whole model is enforced by the Information Commissioner in the UK. That's the UK's version of a supervisory authority. Every member state has one, and its role is to assess compliance and enforce compliance. So a significant role for the ICO. Controllers can outsource processing of activity to data processors. We'll touch on the rules that apply to that shortly. There's an issue around security, of course, in outsourcing processing, and the European Data Protection Board exists to make sure that all of that processing is done so, all of the enforcement is done in a way which is effective across the whole of the European Union. So, what are data subjects? GDPR says that a data subject is a natural person. A natural person is someone who is alive. It's not a company. A company is a legal person. So companies have no rights. An email address like info@itgovernance is not the identifier of a natural person, so it has no protection under GDPR. But anything which is personal data, and that includes B2B data. So Alan Calder at itgovernance.com identifies me, so therefore that's personal data, and it's protected under GDPR. GDPR makes no distinction between B2B information and B2C information. It's all personal data. And GDPR says that natural persons, living individuals, have rights associated with the protection of their data, how the processing of their data is carried out, and to the unrestricted movements of their data within the European Union. The type of data that's within the scope for GDPR is anything that is processed automatically or intended to be processed automatically, and data that is part of a filing system or intended to be part of a filing system. So a loose pile of business cards in the corner of your desk, that's probably not a filing system. It's not going to be subject to GDPR, but if you put that data, those cards, into a Rolodex, or you put them into a CRM system, at that point they become personal data that's subject to GDPR. So those are key definitions: personal data and the material scope. The territorial scope is any organization based in the European Union, a controller or a processor, and it's subject to GDPR irrespective of where the data subjects live or their nationality. So if you're based in France and you're providing services around the rest of the world, people who live around the rest of the world are entitled to the same protection under GDPR as are EU citizens. Organizations outside the European Union but are providing services, paid or unpaid, into the European Union, those organizations also have to comply with GDPR. So territorial scope is very substantial. GDPR is spoken of as the first global data protection regulation. And what's different between GDPR and its predecessors is the size of fines that go with breaches of GDPR. That's one of two things, and I'll come on to the second shortly. The fines go up to a maximum of 20 million euros, or 4% of global turnover. I'd like to stress that those are maximums. They depend on the organization having carried out an egregious breach, negligence being substantial, and we really don't expect there to be terribly many fines, certainly not in the first months or years, that hit the maximum. They're going to be fines which will be proportionate to the size of the transgression and the transgressor, but also designed to encourage organizations to comply with GDPR. So fines will take account of the extent of negligence, and for organizations who are just starting on their GDPR journey today, you're going to be saying to yourself, well, 16 days to get there is not enough. The key thing is that you get started, you get as much done as you can, you have a very clear path mapped out beyond the 25th of May, because after the 25th of May is when you can start breaking the law, and action can start being taken against you for breaking the law. The key thing you want to be able to demonstrate is that you've not been negligent. It may have been, you may only have found out about it now, there could have been other issues, but now that you know about it, you've taken steps. Listening to a webinar, buying document toolkits, determining what you need to do around the DPOs, all of those are steps that you can take right now to reduce your level of negligence. And you worry about fines because there are two ways in which the supervisory authority can get to levy a fine on you. The first is if you have a data breach. If you have a data breach, you have to report the breach to the Information Commissioner. If you're a data processor, you have to report the breach to the controller. You've got to do that within 72 hours of first becoming aware of it. And if you're a data controller, you've got to report the breach, if there is a risk to the rights and freedoms of natural persons, to the ICO. And again, you've got 72 hours within which to do that. If it's going to take you, as it does on average, 146 days to identify and report a breach, you don't want to expect that you're going to get away with a minimal fine, because it means that you're pretty negligent in paying attention to whether you've been breached or not. You need to be, amongst other things, looking at how you can bring down the period that it takes to identify that there has been a breach so that you can report it more quickly. Data processors, note, have to inform a controller irrespective of the risk caused by the breach. You have to report the breach. If you're a controller, you only have to report the breach if there is a risk to the rights and freedoms of natural persons. If there is a high risk, then you've got to tell the data subjects themselves. So of course, if you have to report a personal data breach, then you would expect that you're going to be subject to, at some point, an investigation. So your first challenge is, I'm going to have to report data breaches. You don't want to decide not to report them because you'll have another breach later on, or alternatively, someone will bring a case against you and it will be found that you didn't report data breaches, and that will go to increase the size of the potential fine. Comes into force, as I've said, on the 25th of May 2018. We're coming into the last weeks of a 2-year transition period. Quite a lot of organizations have already made substantial progress to be ready for GDPR, but some data suggests that it might be no more than 15 to 20% of UK organizations will actually be something like compliant with GDPR by the 25th of May. There's a very large number of organizations which still have to get compliant. And importantly, because GDPR is a law, and because there are a number of areas in GDPR where the requirements are not black and white, the reality is that what compliance looks like is only going to become clear in some areas over the course of the next 2 to 3 years. That doesn't mean that you can put off compliance for then. It means that you have to recognize throughout your GDPR journey that you have to pay attention to the changes in the regulation and its enforcement so that you can adapt your privacy compliance framework to meet those requirements. So data breach reporting is the first issue you have to be concerned about. The second issue you have to be concerned about is the rights of data subjects. As a data subject, it's great to know that you have rights and that they're going to be protected. As a controller, it could be an opportunity for you to establish a competitive edge, but it's certainly a major challenge for you, because you have to make sure that data subjects know what their rights are. So the starting point is a privacy notice, which sets out clearly what you're doing with the data that you're collecting, why, how long you're keeping it, and tells data subjects how they can carry out, how you're going to facilitate the exercise of their rights, which include information about what you're doing, access to their data that you're processing, the right to fix or rectify errors, the right to be forgotten, the right to erasure, which, like the right to data portability, is not an absolute right. There are very specific circumstances under which those rights apply. There is the right to restriction of processing while you're arguing over the accuracy or otherwise of data, the right to object to data being processed on the basis of legitimate means, and a couple of others, and the right to be informed of automated decision-making, including profiling and the consequences. Where the basis of processing is consent, and for many organizations, consent is the default. It doesn't mean it's right, but it's the default. Then the data subject has the right to withdraw consent at any time, and the controller must stop processing. Now, what puts the bite into that is that data subjects also have the right to complain to the Information Commissioner at any time when they think their rights have been transgressed, or to bring a case in a law court seeking financial damages for financial compensation for non-financial damages. And you want to think about the likelihood of there being legal firms that might be interested in helping people who think that their rights have been transgressed. So you've got the double whammy of, I've got a breach, that means I've got to report it. If I don't report it, one of the people whose rights has been compromised might decide to bring a complaint, in which case I'll be penalized for not having reported it, as well as for the breach itself. So in reality, the practical route for all organizations is just to make sure you get on with being in a position to comply with GDPR. And complying with GDPR really starts with the 6 data processing principles set out in Article 5 of GDPR. And the principles are that data must be processed lawfully, fairly, and transparently. I'll come on to what's lawful in a minute, and the rest of the words are pretty obvious. Fair means that you and the data subject would think, yep, that's what I expected to happen with my data. Transparent means that nothing is hidden from them. You haven't written complex, difficult to read or understand privacy notices, and all of that flows from being very clear about why you're collecting the data, collecting only the data that you need for a specific, explicit and legitimate purpose, something you can describe to the data subject. Making sure that the data you collect is adequate for the purposes, relevant but limited to what's necessary, kept up to date in order to achieve those purposes, retained only for as long as is necessary for those purposes, not kept because you might think there's something else you want to do with it, kept only for as long as the original reason for collecting it. And then finally, you must process the data in a way that will maintain its security. So 6 core principles, data processing principles, which you've got to work out how to apply to all of the personal data processing you do across your organization. There's a 7th principle which the ICO talks about and which is built into the data processing principles, which is the principle of accountability. Article 5 says that the organization must implement the 6 data processing principles in a way that demonstrates that it accepts it's accountable for achieving the purposes of those principles. The ICO back in January last year said, yes, the GDPR is a new piece of legislation, but it's not about box ticking. It's about moving to a framework, building a culture of privacy that pervades the entire organization. You have to put in place comprehensive but proportionate governance measures, and that of course means a change to the culture of the organization. It's about not trying to bolt accountability on, but embedding accountability into the organization. And what that really means is that once you're compliant, it's not the end of the journey. Once you're compliant, it's the start of the journey. You've got to make sure that you're continuing to further embed and improve the way you do data protection. You've got to continually review risks. You've got to, as you look at developing new processes and systems, come back and review the way those change the risks to data subjects. So it's a journey, is GDPR. Principle of accountability is going to be reflected in a number of ways. The first is going to be in how the board demonstrates its accountability. Corporate risk registers should identify risks to the rights and freedoms of data subjects. There should be a responsible director on the board who's accountable to the board for ensuring that GDPR is properly understood and applied through the organization. You may need a data protection officer. In some circumstances, DPOs are mandated. In others, you will have a GDPR manager, not a DPO, because you won't want to necessarily have the DPO caught by the requirements that sit in GDPR for the role of DPR. You'll want to build a privacy compliance framework, which is a combination of what's called a PIMS, a personal information management system, and an ISMS, or an information security management system, for both of which, if you want to go down that path, there are national or international standards that can provide a specification as to how to implement those, and against which you can be audited as a method of demonstrating compliance. You need to have a record of processing. Article 30 requires you to describe, keep a record of the data processing that you're doing. You no longer under GDPR have to register, but under British law you will still have to register with the ICO. You'll need to have a cyber incident response process to ensure that you identify information security events and incidents and that you can report them as you need to. And doing that effectively depends on, sooner or later, doing a data inventory, a data flow audit. The way you use data changes between the point at which it's collected and the ultimate destruction of the data. And your data flow audit is designed to make sure you've identified all of those uses in a way that enables you to ensure compliance throughout the life cycle. A data protection impact assessment will be mandatory for organizations processing very high volumes of special categories of information or processing data in public places or public authorities, and certainly mandatory where you're making significant changes to processes or IT systems which might usher in changes to risks for data subjects. So the embedding of data protection is going to require data flow audits, data protection impact assessments, and that should be part of, even if you get your initial very basic GDPR compliance steps in place, part of the longer evolution of your compliance strategy should be implementing those kinds of steps. So coming to lawful basis, you have to have a lawful basis for processing data. As I said earlier, for many organizations, consent is the British default. The problem with consent is it triggers the right to withdraw consent, it triggers the right to data portability, and it triggers the right to be forgotten. So in practical terms, consent is not always the smartest thing to do. Imagine how if a customer, you rely on consent to process their payment data, and just after you've completed the contract, they withdraw consent from you to use their payment data. By law, you would have to stop, but you haven't been paid yet, so you're done. You've still got a contract that says you have to deliver, you just can't use their data to get paid. So you would, wherever possible, use an alternative to consent. Consent would include, I have a contract, I'm doing this processing specifically in order to deliver a contract, might be your legitimate interests, could be the protection of the vital interests of the data subject, and there are several others. And you're typically going to want to look at one of the, and they're set out in Article 6 of GDPR, you're going to want to look at which of those lawful bases you can use rather than consent, recognizing that for consent, there is a very, very high bar. And I'll come back to that in a moment. Controllers and processors, because it's the controller that's going to determine what the lawful basis is for processing. Controllers, if they outsource some of the processing, have to make sure that it's done in accordance with the lawful basis they've selected, and that all of the 6 data processing principles are complied with. Processors can only operate under a legally binding contract. That means that for every element of data processing you're doing, you need to establish whether you're a controller or a processor. If you're a controller, you'll determine the means and purposes of processing, and you will be accountable for dealing with data breaches. If you're a processor, you must have a contract. If you're a processor and you under investigation and say, I'm a processor, but I don't have a contract for this, you are automatically, you've broken the law because you're operating without a processor. Worse still, it might turn out that you're actually a controller, and then as a controller, you will have been negligent in terms of your obligations. So get really clear for all personal data processing you're doing, are we a controller or are we a processor? And whichever it is, can we make sure that we've got the right legal mechanisms in place to enable us to demonstrate compliance. So Articles 7 through 9 deal with consent. In particular, in Article 7, GDPR makes clear that consent has to be positive and affirmative. So it can't be a pre-tick box. If you have websites with pre-tick boxes of any sort, those are going to be automatically illegal in 16 days' time. It has to be a positive tick, changing settings, anything that evidences that the data subject decided that they wanted to do something. You want to make it possible for them to make that decision, having given them clear information about what's going to happen. So the written information must be clear, easily accessible, easy to understand, and complete. It can't be gobbledygook in tiny print. None of that will go, and you can't bundle consents. You can't do the typical by ticking this box, you agree that we can process your data for the purpose of marketing, to give it away to whoever we like, to sell it. That would be bundling three different things. You can't do that. You have to ask for consent for each of those activities separately, and you can't penalize somebody if they choose one of them only. Children under the age of 16 are not going to be allowed to give consent for the processing of their data in relation to an information society service. That doesn't get in the way of their right to do a whole bunch of other things, but an information society service like social media, they're not going to be able to do. It's one of the areas where member states have a derogation. The UK bill is going to take the derogation and opt to make the minimum age 13, but it means that any organization providing services which are likely to be interesting to minors will have to have a robust mechanism for ensuring that data subjects are actually of an age to give consent, and the adult that they've asked to give consent isn't just a friend masquerading as. So challenge around children. And then finally, Article 9 deals with what are called special categories of data. Special categories of data are anything that's more sensitive, that is more than just a name and address, for instance. So health data, biometric data, genetic data, racial data, health, sexual preference, political beliefs, those are all special categories of data. And GDPR says it is forbidden to process any of that information unless you can identify from the list in Article 9 an exception to the prohibition. The list in Article 9 includes explicit consents, it includes necessary in order to deliver a contract, it includes vital interests of the data subject, but you need to be able to identify both an Article 6 lawful basis and an Article 9 exception to the prohibition if you're going to process special categories of data. So the bar around the lawful processing of special categories of data is much higher, and that's going to have impacts on many organizations, including all organizations in terms of aspects of HR data. You'll remember me talking about transparency, and GDPR requires transparency. So all communications with data subjects have to be concise, intelligible. The data controller has to be transparent in providing information. And that's particularly around the provision of information in terms of how a data subject can exercise their rights, telling them where the ICO is, making sure that it's easy for them to access the data you hold. You might give them a preference center, you might give them an email address. You certainly need to, where a subject access request is concerned, make sure that you've got a mechanism in place for being able to respond within 1 month of receiving it. So you want to have a method for tracking, date stamping if you can, incoming subject access requests, making sure that you're on top of providing answers to those. Of course, there's going to be some information which you won't provide under subject access request because it's going to compromise another data subject or might be subject to legal protection, whatever it is. So you can't just respond, you've got to go through a triage process to make sure the information you're providing is what the data subject is entitled to have. And of course, you need to make sure the data subject is who they say they are. Your privacy notice, the requirements of privacy notice set out in 2 articles of GDPR. The first is Article 13. It sets out all the things that you have to tell somebody who's providing you their data directly. You can still get data from other parties. You can still buy mailing lists. You can still collect data from social media. But before you use that data, you must issue a privacy notice which tells the data subject all the same things as previously, but also where you got the data from. And you need to do that in sufficient time for them to object to the processing. You need a lawful basis. You can't collect information from a LinkedIn group where somebody's talking about cybersecurity and then start talking to them about buying a holiday in the Maldives. That would not be, by the remotest extent, a legitimate use of their data. It would not meet the test around fairness, so you'd be in trouble. But you could collect data from a LinkedIn group talking about cybersecurity in order to talk to them about your cybersecurity solutions, because direct marketing is a legitimate interest under GDPR. So transparency is important. Having good understanding around lawful basis of process and legitimate interests is a key component to effective marketing and sales activity. As we get deeper into GDPR, you find that it comes back to the idea of building data protection into process by design and by default. Data protection impacts are mandatory for technologies and processes that are likely to result in a high risk to the rights and freedoms of data subjects, and in the specific circumstances I mentioned earlier, where there is processing as high volumes of special categories of data as a core part of the organization's business. So a hospital, for instance, where there is public processing of data collected in the public place or a public authority. Those are mandatory DPIAs. For many organizations, you'll have to design data protection in retrospectively. You'll look to get in place what you can to meet your most obvious gaps as quickly as possible, but you're going to have to go back to all the processes. You're going to have to map the processes. You're going to have to look at where you have exposures, where people can see and access data that they shouldn't, and you're going to have to design data protection back into those processes so that it becomes an embedded part of how the organization operates. And that brings us really on to security. GDPR in both Article 32 talks about security, and in the 6th data processing principle. And to sum that up, it really is that organizations, data controllers and processors must protect data in a way that ensures that the data is secure. It's protected from both unauthorized and accidental loss, destruction, or damage, and you've got to put in place appropriate technical and organizational measures. There's no definition of appropriate or technical or organizational. You've got to work those out for yourself on the basis of how you assess risk. So it's very difficult to comply with GDPR unless you've got a proper risk assessment methodology, if you haven't got a proper method for identifying and assessing risk. There are a number of sensible things that you can do off the bat to reduce risk. Pseudonymization, and in particular encryption of personal data, fall right into that category. The ICO, broadly speaking, sees that if data is encrypted and there is a breach, that there will be no risk to data subjects, and therefore encrypted data is, if there's a breach, unlikely to trigger the need to report a breach. So that should make encryption a kind of default early step in any organization's compliance strategy. In effect, your security strategy, and so if you have an ISMS, if you put in place cyber essentials, any of the things that you could be doing to protect data, you should be doing, and if you can do so in a way that brings with it an independent certification, that's a useful way to demonstrate that you've taken appropriate steps to protect the data of your staff and your customers and partners. All of that fits together in what we call a privacy compliance framework. A privacy compliance framework links the privacy or data processing principles, those 6 principles, with how you deal with governance, risk, and compliance across the organization, and the policies, procedures, controls, and records which demonstrate how well the controls are working are the three major components of your privacy compliance framework. So personal information management system and information security management system sitting within a governance framework is how an organization goes about demonstrating that it recognizes that it's accountable for protecting the data of its data subjects. Who needs a data protection officer? Not everybody is the answer. There are organizations which are processing substantial volumes of personal data. There are public authorities. Those are certainly going to require substantial categories of substantial volumes of special categories of data are going to require data protection officers. But a data protection officer is a mandatory appointment in those circumstances, a voluntary appointment in all others. Whether it's mandatory or voluntary, the role cannot be held in conflict with any other duties. So a head of HR or a head of IT cannot be the DPO, because as head of HR or head of IT, you have a role in determining the means and purposes of processing, and that will create a conflict of duties with the role of the DPO, which is to provide unconflicted, independent advice on how to manage personal data. DPOs can't be dismissed because you don't like their advice. Of course, you can dismiss them for any other normal employment reasons, but from the perspective of providing advice, they're a protected role, and they should be consulted in respect of all data processing activities. They've certainly got a role to play if you have a mandatory DPIA to carry out. They've got a role to play with any DPIAs for that matter, and that is to ensure it's done correctly. And if DPIAs are required, to ensure that they are reported to the ICO, who is entitled to know that the DPIA has been carried out and carried out correctly. So in thinking about DPOs, you also have to think about training. You're going to be training people across the whole of the organization, in particular in HR, in marketing. They'll need basic understanding of GDPR. All staff, in fact, will need an understanding of GDPR. So data protection should be in your staff induction process. Might be delivering it by e-learning or classroom training or stand-up training, but whatever it is, you want to be able to deliver staff awareness training around e-learning on a consistent and coherent basis where you're sure of capturing 100% of your staff. Certifications I've touched on a number of times. GDPR makes provision for organizations to get certifications to demonstrate compliance. Remember that ultimately compliance is going to come down to a judge deciding whether or not an organization has complied with a particular term. So any certifications are a best guess. They're the certifying organization's current best guess as to whether or not you're complying with what its understanding or a common understanding of the requirements of GDPR is. And those are useful. So ISO 27001, which is information security standard, BS 10012, which is a PIM standard, those are useful standards because they help you understand, help you demonstrate that you've complied with some specific requirements. Cyber Essentials and Cyber Essentials Plus in the UK are de facto basic starting points for GDPR compliance where security is concerned. They deal with 70 or 80% of the most basic threats to organizations. They're very straightforward controls. They're inexpensive to put into place, so a cost-effective supplier like IT Governance, which is a Cyber Essentials certification body, for most small organizations will cost only £300 to get certified in a self-help online scenario. There will be new standards and privacy seals which will emerge, and organizations should pay attention to them as they come out. Being certified, though, will not absolve you of the obligation to actually comply with GDPR. So you'll need to have a bit of an eye always to what does the law actually say, and are you satisfied you're complying with that, not just are you complying with the standard that you selected. So I touched early on the transfer of data outside the European Union, and the GDPR prohibits the transfer outside the European Union unless one of a small number of things happens. The first is it's going to a country which the European Commission judges having an adequate rule of law. There's only a small number of those. They are in they're places like New Zealand and Canada. They're not places like the United States. The US is not seen as an adequate data protection regime. You can transfer to places that are not adequate if you have what are called adequate safeguards. So that's standard contract clauses built into the contracts of whoever you're transferring data to. And just remember that transferring data means enabling someone in a different country to look at the data, because processing data includes just taking a look at it. It doesn't mean you necessarily have to move it electronically. The very fact that someone can look at it means it's being processed outside the European Union. There are what's called binding corporate rules, although those are complex and unlikely to be pursued by many organizations. So transfers on the basis of adequacy, subject to appropriate safeguards. Essentially, you have to make sure that the obligations you've entered into as a controller are capable of being exercised wherever in the world the data goes. Encryption, particularly important if you're moving data internationally, because it reduces the risk of interception and reduces the risk to the rights of data subjects. Where America is concerned, the previous safe harbor arrangements were discovered to be invalid, were put aside, and in July 2016, the EU-US Privacy Shield came into force. It's subject to an annual review, but it enables a US organization to shelter if it goes through the registration process and claim it's operating within an environment that meets the European Union's adequacy requirements. So if you're dealing with a cloud-based organization, you need to make sure that if it's US-based, it's registered under the EU-US Privacy Shield. Otherwise, you've got a much bigger challenge in moving data to that cloud service provider. An independent supervisory authorities, GDPR requires every member state to have an independent supervisor. In the UK, that'll be the ICO. Its tasks are to monitor, enforce, communicate, and promote awareness. It can investigate, correct, advise, and, as I said before, enforce. And so it can levy fines. Of course, the fines it levies can be appealed, and so you would expect supervisory authorities to be careful about what they levy, but that doesn't change the fact that they have the power to levy fines up to 20 million euros. One of the good things in GDPR is that you can select a single supervisory authority to be your lead supervisory authority for all your activity across the European Union. And you can, that's typically going to be the supervisory authority for your main place of business, but it means that if you have a breach, you can deal just with one supervisory authority. It can simplify significantly your regulatory compliance process. So that's worthwhile thinking about, as is the fact that you can appoint a DPO on a contractual DPO as a service basis. You don't have to employ one full-time yourself. So the combination of the requirement, if you're outside the European Union, to have probably have a DPO, to have a representative inside the European Union, and to select a lead supervisory authority might mean that you choose to do all that in one particular state in a way that enables that all to operate effectively for you. And finally, the European Data Protection Board, which, as I've said, comes into force on the 25th of May. It's mostly made up of Working Party 29, the people who've been working to create GDPR and to provide guidance over the last 2 years. But its role is to basically ensure a common or level playing field for organizations operating across the European Union, a consistent application of the regulations, not an appeal body, it's an apply consistency body. The ICO, to sum up, said accountability does require an upfront investment, but that's a good thing because it gives you a real opportunity as a controller or processor to demonstrate that you care about data. And over the years ahead, she was implying caring about data will become a competitive edge. Hey, she says, if you don't want to do it for that reason, there's a very big stick. And do bear in mind that the wielding of that big stick is not going to be based on the transgression, but what the investigation finds. So if you leave a laptop on a train, you might think you get away with a small fine, but if the investigation reveals that you've got hundreds and hundreds of laptops, none of which are encrypted, then you're likely to get a big fine, because that's pretty negligent where laptops are concerned. So don't leave yourself open to enforcement action that could bring big damages to reputation or bank balance. Make sure, particularly if you're starting today, that you do the easy and fast things that you can do to get yourself out of the danger zone. And those probably start with a governance framework. Get it onto your board agenda. Make sure that there is a risk register. You've got a proper accountability framework. Allocate roles and responsibilities. If you need a DPO, get one appointed as fast as possible. If you're going to have a data protection manager, go down that route. And then work out what data you've got. Work out which are the data sets which are most at risk, and take steps to shift that to a lawful basis of processing. If you're processing employee data on the basis of consent, you'll need to issue, at the very least, an employment contract addendum, because consent's not going to be valid under GDPR. You can only process employee data to fulfill a contract out of legitimate interests or for statutory reasons, some combination of those. So identify the data you are wholly unlawfully, put steps into place to change that, then do a more detailed data flow audit that enables you to work out exactly where your compliance gaps are. Get your privacy notices up to date as fast as possible. Make sure they reflect Articles 13 and 14. Get your data subject access requests processed and robust and legal. Create your records of processing, the description of what data you're processing, how, when, where, why. Do a security gap analysis, and then do security remediation. Your privacy compliance framework, Cyber Essentials, ISO 27001, all of those are frameworks that you can deploy to demonstrate you're taking sensible steps around data protection. With all that, you're still going to have a breach. So you need a breach response process. You need to be able to respond quickly. So work it out. Work out what are typical breaches, design an incident reporting and breach response program, teach people how it operates, make sure it can operate quickly and effectively, and then make sure across the whole of your privacy compliance framework you've got an ongoing mechanism for auditing and continually improving what you do. So 9 steps to GDPR compliance. If you're only starting today, you're not going to complete them all in the next 16 days unless you're a very small organization. The key thing is that if you're only starting today or you've only just started, you map those 9 steps into a timetable. You can demonstrate that you've taken the first steps, and you can demonstrate you've allocated resources to taking the next one. That'll go some distance, we believe, to enabling you to demonstrate, should there be a breach, should there be enforcement action, that you're not negligent, you have actually taken proper steps to meet your compliance obligations. Remember that it's quite likely that any compliance activity will be prefaced with there has been 2 years to make the journey. How come you only found out about it now? We don't know how that's going to play out, but the reality is that this is the end of a 2-year transition process. So there's quite a few ways in which in IT governance we can help our clients around the world, and we've got websites, as I said, in the US, in Europe, and in the UK, so you can buy through any one of those websites and currencies that you want to deal with. But we have self-help materials, pocket guides, implementation guides for people who want either to follow written advice or who want to share written advice internally. There's a set of documents that you can deploy, which gives you substantially all of what you need to be able to deploy a personal information management system. There's a gap assessment tool, which with a bit of quite straightforward training, you can learn how to use. It enables you to get very clear what your gaps are. And the compliance gap assessment tool, again, is a practical way, if you don't have much time, to identify what it is you've got to do and put in planned processes for doing it. There is foundation, practitioner, and impact assessment workshops. The certifications that come with the foundation and practitioner courses are, of course, useful, and those courses are running often as a 5-day foundation and practitioner combi course in centres around the UK and in Europe, and there are still odd spaces here and there, but you will need not only for project leads but for people throughout the organisation to make sure they have appropriate levels of training. And we have consultants. As I said, we're a one-stop shop, so we can provide any mix of services you like. We can do a gap analysis for you. We can do a data flow audit. You can buy a data flow audit tool or take out a subscription to one anyway from one of our websites. We can help you with implementing a PIMS or an ISMS. We can do a basic cyber health check, particularly useful if you also have to comply with the Network and Information Security Directive. So there's a whole range of services that you can get from our consultancy team. All of that accessible through our web shops. You can go to itgovernance.co.uk or any one of the other web shops. You can get information from our various social media feeds. You can see stuff on Twitter, LinkedIn, Facebook. And of course, you can come back to future webinars. If you go to itgovernance.co.uk/webinars, you'll find there is an ongoing series of webinars related to GDPR, special subjects in GDPR, and related issues like information security, business continuity, and so on, all of which are, as is this one, free for you to use. And that, ladies and gentlemen, brings me to the end of what I was planning to say. So I'm now going to turn to questions. And just to reiterate, for those of you who hadn't already done that, the question panel in the panel in front of you on GoToWebinar can be used to ask questions. And what I'm going to do is I'm going to go through and I'll pick out questions. I'll read the question to you and then share with you my answer. If you have more questions, please do stick them into here. I look after a large database of records going as far back as 220 AD. Some records contain people's names, but I wonder if the GDPR still applies to records way in the distance past. Yes. If the person's passed away, then GDPR doesn't apply because dead people don't have rights. So the challenge for you with records going back into early Roman ages is working out which of those people are still alive and which ones are dead. And there is some practical sense in simply deleting all records which are older than your retention date. I can imagine an investigation where an investigator finds that you're holding records which are very old and therefore works much harder to find the ones that you shouldn't hold. For USA web agencies handling sites that serve individuals in the EU as data processors, what are our obligations? Does GDPR apply only to our EU sites or all of our worldwide clients? So this is a little challenge because what GDPR says is that organizations providing services into the European Union, paid or unpaid, must comply with GDPR. So until we've had some cases, we won't know for sure what that means. Some organizations take that as meaning the whole of the organization that's providing services must comply, and that's meant that some of them have narrowed the scope of compliance. They've locked down the bit of the organization that's providing services, they've given it a separate management, they've limited access and so on. Or set up separate companies. Other organizations have just said, fine, it's good practice anyway, it'll catch on here in the US, we may as well deal with it. But in practical terms, you get hold of your lawyers and you ask them to tell you exactly what they think you should do in terms of compliance with that phrase, and that's what you do, and then you watch the first court cases, which sadly will not appear for probably 6 to 9 months. Do charitable organizations need to comply? Yes, there's no exception for charities, no exception for public authorities, there's no exception for small organizations other than small organizations under certain circumstances don't need as much documentation, but all organizations have to comply. In the UK, the Information Commission has demonstrated that she's perfectly capable of fining charities that don't comply. The relevance of this information to a one-man consultancy, I'm having trouble identifying, I understand that. However, if as a one-man consultancy you're collecting information about your clients, you are an entity processing the data of other people. The only exception to GDPR compliance is data collected in a purely personal capacity. So probably if you have a list of your friends, that will be outside the scope. But frankly, if you're a single person operating as a consultancy, you're collecting data about data subjects, even if it's the names of your customers and the names of your suppliers, that's personal data, you have to comply. Hey, you might decide that there's not a lot of risk to data subjects, you might decide that you're not going to bother, but the requirement for GDPR is that you have to comply. Would a company that provides laboratory information management software to global customers be considered a controller or a processor? Well, again, that depends. If you're providing management software and you have no role in what data gets put into it or how that data is managed, then you're going to be neither a controller nor a processor, except that you'll be almost certainly hosting data. And so I would say that in respect of hosting, you're a processor, and you'd want to make sure your agreement with your customers is limited to we process data in terms of in the sense that we host it. This is how we protect it. Otherwise, you're on your own client. If I'm sharing my employee's info with a third party, Do I have to ask the third party for anything from them stating they're compliant? Well, as a controller, you are on the hook for GDPR compliance. So you have to make sure that a processor you're using is itself compliant, because you're outsourcing both the processing of the data and the obligation to be compliant. If there is a breach and the organization you've chosen to use is not compliant, it's you, the controller, that's going to get the fine. And the ICO has been explicit about that for 18 months. We don't expect any change in that reality at all. If I will never process data, I only want to keep contacts on my CRM system. Keeping contacts in your CRM system is processing. The definition of processing includes storing, taking a look at it. Anything you do with it is called processing. So you don't want to think of processing as an active thing. It's the term that GDPR uses to cover anything to do with personal data. Store it, take a look at it, share it, carry it around in your back pocket. That's all processing. So you have to comply with GDPR. Those organizations are not compliant. You just got to get started. You are where you are. There's no point panicking. Get started. So the steps that I was sharing in that final slide is really what you've got to be thinking about. Get started on your journey as fast as you can. I would do things like penetration testing, cyber essentials. I'd try and reduce the risk of a data breach. I would be trying to get key privacy notices in place. I'd try and buy myself time to be getting on with putting in place all the rest of the requirements. I'd certainly get it onto the board agenda. What about verbal consent? If you meet someone at a road show, talk to someone on the phone, ask them if they want to be on your mailing list, there's no proof that they gave you verbal consent. If they do give you a verbal yes, can you then email them to confirm consent? Yes is yes to the second. Verbal consent counts as consent, but sadly GDPR requires you to have evidence that you got consent. So what that really means is if you get verbal consent before or when you upload the data to your CRM system, send them an email which complies with the requirements of Article 13 saying, this is how we're processing your data, you consented to it, this is how you can withdraw consent, this is how long I'm going to keep it for. That way you've got evidence that you have their consent, you've told them they can withdraw consent. So people who have learning disabilities who may not understand, GDPR is not explicit around it, so you're probably going to have to turn to other legislation. GDPR at least is explicit that people, you have to be able to demonstrate that people properly understood, and so I suspect that GDPR will come to accept that how member states deal with learning disabilities and those people having their data processed will apply in terms of GDPR. So exceptions like vital interests will still continue, but a duly appointed guardian, I would expect, would still be able to consent to the processing of that data. John Smith at customer.com email is caught by GDPR. It identifies somebody. The fact that it's an email address at work doesn't change the fact it's an identifier. You don't have to have consent. You have to have some lawful basis, which could be consent, but doesn't have to be. If you've got customer and supplier bank details and their entities, no, that's not covered because those are not natural persons. Can a CEO be appointed as a DPO for their business? Well, I think that's kind of hard because the CEO is probably the ultimate person who's determining the means and purposes of processing data, and so making them DPO would almost certainly create a conflict of interest which would be impossible for them to avoid. So I would say absolutely not. You need somebody else and probably to outsource it under those circumstances. Small organizations that don't have complex IT systems, how do you handle emailing information? Well, small family-owned care homes, some sense of information about a person accidentally went to the wrong person, that would certainly constitute a data breach. Try and use an encrypted attachment always, open with a password. There isn't really an easier way, either an encrypted attachment or there's growing numbers of companies who sell software which is designed to easily encrypt email, although that's not yet always available to non-corporate entities. So there are challenges for small organizations in deploying encryption, but it's one of those areas to look out for in the next months. Please don't ask your employees for consent to keep their data, because GDPR would make that an invalid basis, and invalid means that all the processing you're doing is illegal and the data subjects can instantly ask for everything to be erased. So if you're currently relying on consent, stop. Issue changes to contracts which shift the basis of processing employee data to statutory requirements, delivering on a contract or legitimate interests, pretty important. If you sought consent for an existing subject but you hadn't received a response, well, you needed to have decided before you sought consent what you were going to do. And if you haven't got consent and you've given them a deadline, then you need to stop processing. You might go back and think about whether consent's really what you want to rely on. It's not too late to say, actually, consent is wrong. We've been emailing these people now for years. They've had the right to opt out up till now. We know they're interested in the subject, so actually a better lawful basis might be legitimate interest. And you can do a legitimate interest test and bingo. I'm seeing some businesses outside the EU, particularly in the US, being fairly cavalier, even though they service people in the EU. Practice, how will GDPR be enforced outside the EU, particularly for medium and small businesses? Through international law. You would have seen that it's perfectly possible for British citizens to be extradited to the US and vice versa. It's perfectly possible for the European Commission or for the Information Commissioner to sue organizations outside the EU under international law for breaking a law that they're required to comply with. And of course, it's going to take some time before there's a solid body of law, but the fact that an organization has been cavalier for the first year because they thought they'd get away with it is likely to be taken into account in any action brought against them. And quite often those organizations are outside the European Union are going to be caught by the fact that their customers inside the European Union are going to say, actually, we don't want to use you because you're not GDPR compliant, and we're in trouble if, as a controller, we outsource services to clients that themselves are not GDPR compliant. A company with 2,000 employees, you probably don't need to nominate a DPO unless you are processing high volumes of personal data as a core activity. Employing people isn't the core activity of the business. If you have hundreds of thousands of people visiting websites, which is what you run, it's quite possible that you might be, but you need to take advice on that. Do we have a data retention? Yes, you should have a data retention and purge policy. Are you allowed to collect CRB checks on all new starting employees? Of course you can. There's nothing in GDPR which changes what you can and can't do in that respect. All it means is you have to tell data subjects that's what you're going to do, and you can only keep the data for as long as is necessary for the purposes. And the purposes will usually be to confirm they've passed. So once you've got confirmation, you shouldn't need to keep the detail of the actual check itself. Ladies and gentlemen, sadly, that brings us to just beyond 4 o'clock. So we're running right out of time, and my voice appears to be packing up. Does the right to be deleted, I'll just take 2 more questions. Does the right to be deleted mean more than a contract to deliver a service? I noticed you mentioned that payment details could be removed before the transaction was finalized. No, that's only if you're relying on consent. If you're relying on consent to process data, remember that the data subject automatically has the right to withdraw consent. And the fact that they withdraw on consent simply gives you a problem. You still have a contract that you have to deliver on. So all I was saying there is don't rely on consent, rely on delivering a contract, one of the lawful basis of processing data for any information that you need in order to fulfill a contract. And as a last question, processors can be employees of the controller? No. For GDPR, a processor is a third-party organization to whom a controller outsources some part of the processing of the data that it's collected. So, ladies and gentlemen, I'm sorry, we are out of time. I'd like to thank you all for being with us. I'm sorry I haven't been able to get to all of your questions, but I hope you found that useful. As I said, do come on to one of our websites. We'll do everything that we can to help you in your GDPR compliance journey, and look forward to welcoming you on one of our future webinars if that's useful. Have a good afternoon. Bye-bye.